Howdy, and welcome to another episode of Cooper's Code Lifecycle of a Case series, where we provide tools and tactics for the different phases of a case. We're compiling all of these episodes into a playlist on our YouTube channel, so head on over there if you want to see them all. Once the case is resolved, and by resolution I mean it's either settled, one has a judgment that has been made final, the appeal is done, however it is completed, then there are a few more steps that one needs to go through in terms of the resolution process. And there were different places we could have put this. I feel it's most appropriate at the case closing section because it's one of the final steps. And here we're talking about a minor's compromise. So what is a minor's compromise? When one has a minor or someone who is otherwise incapacitated, in essence, someone where a guardian ad litem has been appointed, someone who is there to help guide the person who can't take care of themselves in all ways. That's what's known as a minor's compromise. You have to have the court's approval of the resolution. So in settlement terms, the court is actually going to take a look at whether the settlement is okay. And just some public policy behind this. There is a concern that someone, a minor or someone who is otherwise incapacitated, can't take care of themselves. And in that situation, those individuals need the court, a judicial officer, to step in and make sure that everything is okay, that family members aren't taking advantage of the person, that the insurance company who resolved the case isn't taking advantage of the person, say, getting them to settle a case for cheap, that the lawyer who represented the person isn't taking advantage of them in terms of the fees that were charged or the costs that were incurred. And judicial officers take their jobs very seriously, as they should when they're going through this process. So a minor's compromise uses a judicial counsel form. It is subjected to a high level of scrutiny, and the court will go through and see, how did this case resolve? What number did it resolve for? Because most of these are settlements. If it's a verdict, they're not going to question the verdict because the jury did the verdict and that process has all been done. But because most of them are settlements, the court is going to take a look and make its own assessment about whether this settlement is acceptable. The court is also going to take a close look at where the money is going. So that's making sure that the fees are an appropriate amount of fees, that the costs are handled appropriately, and know that in a minor's compromise, that the attorneys are obligated to share in the costs to the tune of their attorney's fees. What do I mean by that? If you are charging a 25% fee for a minor, which is a relatively standard minor's fee, then if you expended $100 in costs, 75 of those dollars would be paid by the minor, associated with the minor. 25 of those would be paid by the attorney. So that's the sharing in the costs. So the court is going to take a look at that to make sure that that is complied with. The court is also going to take a look at where the money is going. There are three ways in a minor's compromise that the money can be handled. None of them are great outcomes, but you need to recognize that the court wants to make sure that it is the minor's money and the minor ultimately has the control over the money, even if that minor can't control it in the moment. So the old-timey initial way that this was handled is what's known as a blocked account. So a blocked account means the money goes to a bank, it gets deposited in a special kind of account, and the only way that money can be withdrawn from that account is by going to court and saying to a judicial officer, hey, we need to withdraw money for X. Usually what ends up happening is that money sits there until the minor turns 18, and then one goes to court and asks the court to release that money. The downsides of a blocked account are huge. I would say it is the least favorable option for resolving a case. Why? Having been through this process once with a client who insisted on using this vehicle, I went with the client to the bank and we were there for 5 hours. And we were there for 5 hours because the branches don't have anyone who really have any level of sophistication, even at the larger downtown branches. So they are having to reach out to their headquarters and to legal to try and figure out just what the heck you're asking for. And it scares them because they're not common, so they don't know how to do it. And eventually we were able to put it through. But then 5 years later, I'm back in court representing that client to have the money withdrawn. And the interest rates for these blocked accounts are kind of standard savings rates. And while interest rates have gone up over the last year or so, generally interest for these are pretty poor relative to other investment vehicles. So I would say if you have to do a minor's compromise, just recognize that a blocked account is really not the best way to go with them. The other vehicles that are what I would suggest is good potential vehicles is a CUTMA 529. So what is a CUTMA 529? That's California Uniform Transfer to Minors Act 529. How is that different than a standard 529? And what is a 529? A 529 is a tax-deferred vehicle for providing money to a child where, in essence, when the money comes out, you don't have to pay taxes on it. But when the money comes out, you can only use it for specific purposes. So 529s are a common investment vehicle for parents saving for their kids' college. So you get the benefit of it going into the market, you get the benefit of the tax profile reduction, and you're able to withdraw it for tuition payments for college or other college-associated costs, books, living expenses. They're spelled out specifically under the rules under 529. So how is a CUTMA 529 different than a 529? A 529, even if you make it in the name of your child, is owned by the parent. So give you an example, our son Bennett, we opened up a 529 for him. If I suddenly decided that I didn't like Bennett anymore and I was going to want to use that money for my niece, bad joke, but I could, in theory, say, well, we're not going to use that for Bennett. We're going to use it for my niece. Bennett does not own the 529, even though I originally opened it in his name. A CUTMA 529 is different. A CUTMA 529 is owned by the minor. So when you go to court with a minor's compromise, if a 529 is considered to be a good vehicle, so most kids are going to do some form of education post high school. If that's the case, a CUTMA 529 can be a very good vehicle for parking this money. The other vehicle that tends to be a very good one, that it needs for most structure brokers, they're going to want to work with a dollar figure typically over, I think it's $50,000 at this point. So if you have an amount of money and a 529 may not be the right vehicle, then a structure is another good way to do that. Why is a structure useful? Structure allows you to get the benefit of market returns. So you can put the money into that tax-free annuity. And then the money comes out when the kid is, at some point past the age of 18. So there are an infinite ways to structure funds, but a common way of doing that is having them come out as lump sum payments, almost like a 529 to pay for college, or pay for a deposit on a house or some other way of having that money come out in chunks. Sometimes parents like to make sure that kids don't have too much access to too much money right away. So it may not all come out when they're 18. Some of it may come out, depending on how much money they're receiving, when they're closer to 25. Also, if you have a very high value case where you've got an incapacitated minor and their expenses are going to need to be taken care of above and beyond what the parents can afford and above and beyond what government services provide, then you may end up with a situation where that structure is starting to pay earlier in the process. All of this is very nuanced. All of this gets a close court review. As you prepare for a minor's compromise hearing, recognize that because of the nuance with these and because of the questions that the court can ask, that it's not unusual to end up having to go to a hearing more than once for a minor's compromise. They might want more information. There oftentimes are things that they want in terms of, we want to see proof that the money was deposited. So submit that within 90 days, and then we'll have an order to show cause for the deposit that comes off so long as you submit the proof of that with the court. A parallel piece to the minors compromise in resolving cases are what are known as special needs trusts. So if you have an individual who is receiving a lot of governmental benefits, one of the things to consider is whether a special needs trust is something that is going to be appropriate. Now, recognizing that governmental benefits programs and thresholds can change, what I'm going to do is just talk in very general terms about a special needs trust, what it is, and generally how it's done. This is a specialized vehicle, and it is best to get a specialized lawyer who does special needs trusts if that's something that you're going to need in your case. So, and I'm bringing it up shortly after talking about minors compromises because oftentimes it's an incapacitated minor, somebody who's had very traumatic injuries, who may be receiving some form of Medi-Cal, who may be receiving some form of other support services. Oftentimes, you might need to do a special needs trust in association with a minors compromise. The other place where you see it is somebody who has such profound injuries that they may not be working again, whether that's the way the person came to you with their case, or whether it is a result of the injury. You're going to want to make sure that they're able to continue to receive benefits. So what is a special needs trust? A special needs trust is a specialized vehicle. Again, best to hire an attorney who does these on a regular basis, where the money that the injured party receives goes into this trust and can only be used for very specific things. Now, the benefit is that it allows them to maintain their governmental benefits. So if they're on SSDI, if they're on Medi-Cal, if they have other benefits that they're receiving, they're able to keep receiving those. The special needs trust, though, can only be used for very specific things. So that they can't just get that money parked there and go out and buy a Mercedes. That said, if they need a specialized transportation vehicle because they are disabled, arguably you could use that money to buy a specialized transportation van to move from point A to point B. So these are things that will benefit them that aren't going to be covered by their governmental benefits programs. There are also very specific reporting requirements for special needs trusts. So really the takeaway here is if you have a client who's dependent upon governmental benefits, just have a bell go off in your head that I might want to look up special needs trusts and see about consulting with a special needs trust lawyer about whether this is the right vehicle for the client. One additional piece on this, because it's specialized and because it's outside of the scope of the representation of most personal injury lawyers, that is typically a case cost. So if it costs $4,000 to $7,000 to set one of these up, and my pricing might be off. It's been a while since I've had to do one of these. That's a cost that is usually absorbed by the client and typically approved by the court if it is built into the minors compromise, if there's a minors comp associated with a special needs trust. So that's minors compromises, that's special needs trusts. The other part that is part of the case closing process are liens. Now, I want to stop here and say this is a cursory overview of liens. It is not a deep dive into liens and strategies for lien resolution. For that, I recommend people, if that's really what you want to hear about, pause here, go to one of our first episodes. I have the wonderful Hendrik White, who was with us and a lien specialist. He does a deep dive into how we address the various types of liens and the pros, cons, benefits, and negotiating strategies. But as a case closing piece, one of the things that one needs to do is go through and make sure that all of the liens are addressed. Why is this usually done at the end? While you can come up with strategies and you can sometimes negotiate with lien claimants earlier on in the case, almost all the time, they want to know how much money did you get and what are your fees going to be? And then they'll start talking with you about negotiating those resolutions. So there are standard liens almost all of these are going to be some form of medical lien. The standard liens are typically resolved under the common fund doctrine, where you are able to say, look, you would have not gotten $1 unless we did our work. Our fees are a third or 40%, and we spent $10,000, and you're on the hook on a pro rata share of that. And so you start there and start trying to negotiate them down. If there's not a lot of money, if this is a minimum policy, a $30,000 policy, then sometimes what you'll end up with is rule of thirds. And that is, look, everyone's going to have to take a bath on this. So, our fees are a third, the client's getting a third, you get a third. Different carriers respond differently to fee reductions. Just know that going in. And the reason I say this is because sometimes we will reduce in cases where there's not a lot of insurance, there's a significant injury, and the client probably would have gotten the policy even if we weren't there. We will reduce our fee. We want to make sure that the fee is commensurate with the work that was being done on the case. And that can sometimes be beneficial with some carriers to say, look, we're not taking a fee in this case. We'd ask you to waive your lien. Sometimes they'll do it. But on occasion, you'll come across a carrier who will say, oh, you're not taking a fee? Well, geez, that just means the client's getting more money, so we don't need to reduce our lien as much. Or, well, if you're not taking a fee, then the common fund is not applicable here. So just get a sense as to who you're dealing with before you start indicating that there's going to be a fee reduction. You can sound them out on how they respond to fee reductions. The other awful lien that people come across on occasion are what is known as self-funded ERISA liens. Those self-funded ERISA liens are just terrible. I mean, there's no way around it. Usually they've contracted around all of the tools that we have in state court to reduce liens, and they're subject to federal law, so they can do that. The only thing I think that are worse than self-funded ERISA liens are union pension fund liens, Costco liens. Those have come up recently for us. Those entities typically will reach out to the member, the person who's insured, and say, we aren't going to cover any of your, it looks like you were involved in something awful. We're not going to cover any of your medical expenses going forward unless you sign off on this thing that, in essence, the payments you're receiving are a loan against any resolution that you have. Some of these will even say that if you receive money, we won't pay for any of your medical care going forward from the incident once the lien is resolved. So just know that there are some of these awful ones out there, and they're a pain in the ass to deal with. Medicare and Medi-Cal require one to go through the CMS portal. Those can be negotiated, and there are other tactics, Ahlborn being one of them. I'm just going to say the case Ahlborn, Google it, AI it, and if you have a case where that might be the right strategy, consider using some of the tools available there. But just know that you need to go through that process. And generally, though, they are willing to negotiate and get better outcomes on liens. So one final piece on liens. Why are liens so important to fight on? It's because every dollar you save a client on the lien side is an actual dollar in their pocket. These are not subject to fees. And so while it takes all of us a little bit of extra work, sometimes a lot of extra work to engage in lien fights, know that it's highly beneficial for the client. And it's part of the service that we offer. We're here to fight to get the most money we possibly can for our clients, both from the settlement or verdict side. We want to get that number really high. And then on the lien side, we want to get that number really low so that you get that nice big differential in between the two. And that's the client's money. When one is finally done with the case, one will have what is known as a distribution report. That's what we refer to it as internally. Distribution report will list the money that is coming in, the attorney's fees, the costs, and then how that money is being distributed. So in essence, the net to the client, we will usually do at least 2 distributions. So distribution number 1 will reserve money for the lien, meaning the full amount of whatever the lien is. If the lien is $50,000, we'll reserve $50,000, go ahead and pay the client, and then that $50,000 will hold and do the lien negotiation. And when we're finally done with the lien negotiation, we'll do a second distribution report. The learning I'll share going forward is that lawyers tend to not be great at math. Lawyers tend to be eager to get the money to the clients. I recommend that if you have a bookkeeper, that your bookkeeper do the distribution report. And then if you have another smart person in your office who knows how to do math, have that person go through and double check things. The reason for that is the distribution report is going to be one of the last moments you have to engage with your client. And if there's a math error, and particularly if there's a math error that is disadvantageous to your client, while you can redo it, it's really embarrassing and it leaves a bad taste in the client's mouth. So having a second set of eyes on that is a good way to reduce the chances of errors. The other piece on that is on your cost side, it's a good opportunity for you to go through and make sure that all the costs were properly entered in the case. So in any environment, there's the chance of an error being made in terms of things being flagged wrong in bookkeeping. So as the lawyer who's handled the case, going through and seeing, all of the expert costs, all of the deposition costs, any travel fees or hotel fees, if you see things where like, oh yeah, I ended up staying an extra night to do X that should not have been included on my client's behalf, that's your opportunity to go through and strike those so that the client is not the one going through and questioning you. You just want to make sure that you're as above board as possible and do the right thing as far as that's concerned. An additional piece that we like to do is on our distribution report, we will usually have a second page that tells us exactly where the money is going and how the money is going. So what do I mean by that? If we're receiving fees, the dollar figure that we're receiving and how it's transferring from the client trust account to our account, usually by wire. Same with costs, because costs are going to be a second line item. If there's a referral fee, what that referral fee is or co-counsel fee is. And again, is that going by check? Is it going by wire? If it's going by wire, to what account? Same with the client money, same with lien money. The reason for this is so that you have a one-stop shopping should anything come up down the road to say, this is how all the money got handled in this particular case. It's nice to have that all in one place. Finally, with the distribution report, we usually like to do and recommend all lawyers do a client exit interview. And that exit interview is twofold. It's to help make sure that the client feels like everything is done, and to IDOT and T-cross and make sure any sort of final instructions are covered with the client. And then also to learn where one excelled and where one can improve. So when I say confirm everything is done, you want to make sure like you've received your funds. Do you have any questions about what we've done? Do you have any questions about what we're doing with your case file? For example, we can make a digital copy of the case file available to the client. We will tell the clients typically that we will maintain your digital file for a minimum of 5 years. And realistically, we oftentimes don't do more thorough purges absent your request that we do purge it. So we told them that so that if something comes up down the road, a medical record that they want, they perhaps didn't save in the right place or didn't ask us for, we have that and we can give it to them. We also will typically answer any client questions. We want to make sure that they know that typically personal injury resolutions are not taxable in terms of what they received as far as those dollars are concerned. And that if that question comes up with their accountant, they or their accountant should feel free to reach out to us and we can point them to IRS periodicals as far as that's concerned. We want to encourage as much feedback as possible. And so you want to create and invite opportunities to provide feedback where one can improve. Are there ways in which you feel we could have done better in terms of how we were handling the case? How responsive were we? Would you have liked more communication, less communication? Those are all ways where one can learn what's beneficial in terms of how to help people going forward. We always encourage them to call with any sort of future questions that they have. one of the things you want to do is you are working with your clients is remember that your clients oftentimes become future referral sources. So to keep that door open, hey, if anything comes up with you or a loved one or a friend, consider us your first line of defense. Even if it's outside our practice area, reaching out to us, we oftentimes know somebody in the area. We can help point you in the right direction as far as that's concerned. Then when you are totally done, you want to make sure that you formalize that thanks for being a client. We've resolved your case. The representation is formally ending at this point. You continue to be a friend of the firm forever going forward. And then if you've had a good relationship with the client and you feel that a review is appropriate, you want to see if they're going to be willing to review you. Google reviews and other reviews tend to be very helpful in that client development process, getting future referrals, getting future business. So that's the case closing process in a nutshell. Thank you for tuning in. If you enjoyed this, we're compiling all of these episodes into a playlist on our YouTube channel. So head on over there if you want to see them all. If you're enjoying what we're doing here with Cooper's Code, please help us extend our reach by giving us a 5-star review on Apple Podcasts and consider sharing an episode with a friend. Please email us at podcast@coopers.law with questions, comments, feedback, and suggestions you have for who you'd like to see on the show. To all of you doing justice out there, happy hunting.